The Supreme Court of Nigeria will today be reviewing its verdict on the governorship election in Imo State, which some weeks ago unseated Emeka Ihedioha of the People's Democratic Party and enthroned Hope Uzodinma of the All Progressives Congress. However, the People's Democratic Party has called on Chief Justice of Nigeria, Justice Tanko Mohammed, to recuse himself for perceived sleight of hand demonstrated during the first mention of the case at the Apex Court. For an analysis on all of these, we're now being joined from our Abuja studio by Majeed Dahiru, a journalist, syndicated newspaper columnist, and political affairs commentator. With PDP calling on the CJN to recuse himself from the review, could this be another constitutional crisis brewing? And then how can the impending logjam be avoided? What's shaping up to be the likely outcome? Welcome to the program. Good morning.
Good morning.
Good morning, Majeed.
Good morning. Good morning, and thank you for having.
Yes.
Thank you so much. Thank you so much for having me, Doctor.
Well, we should be the ones thanking you for honoring our invitation to appear on the morning show. Very quickly, what do you think?
It's a pleasure, sir, Dr. Ruben.
Thank you. Is the PDP right to request that their lordships should recuse themselves from the Imo State gubernatorial case, having been the ones who decided in January that Emeka Ihedioha should be removed and Hope Uzodinma should be given a certificate of return? Is the PDP right in alleging bias and the possibility of justice not being done?
Yes, I think the PDP is right to actually harbor this fear of bias. First and foremost, you will recall that the way and manner the current CJ came into office was quite controversial and was perceived by a lot of people then as a political move to actually have somebody who was, purportedly pliant to the wishes of the ruling APC as the head of the judiciary in Nigeria. And, that's the Odoge ouster, the controversial way in which he was removed from office, is still haunting the current CJN. And that is why that should have been avoided in the first place. And secondly, yes, for a panel that sat and actually delivered a judgment that is also equally very controversial, one of the most controversial in recent times, that has necessitated a request for a review of its own judgment. I do not think the same panel should sit on the review of its earlier judgment. I think it is quite apt for the CJN to heed the call of the PDP, that is the party in this matter, to actually constitute a fresh panel to look into areas of concern. And I think there are so many areas of concern about this judgment in order to come out with something that will be acceptable to all parties, because justice must be seen to have been done to all parties, to the state, to the litigants, to the respondents, and everybody involved. So I think the PDP is quite right in this instance to ask the panel to stand down for a freshly constituted panel by the CJN.
Thank you for that. But what is the likelihood that that will happen, whether or not their rights to demand their rights, which they are within their rights to make this demand? What's the likelihood?
It's been the practice that when interested parties in the case before any court of competent jurisdiction express lack of confidence in adjudicating officers, it has always been the practice for such officers to stand down. I mean, recall the similar scenario that involved the outgoing president of the Court of Appeal, when the PDP also expressed concern about the fact that her husband was a chieftain and a sitting senator on the platform of the ruling APC, and feared that she might not be in the best of mind to objectively adjudicate on this matter. She actually recused herself. So I think it simply follows a tradition in the judiciary, and it's really the right of litigants or interested parties in the particular case to ask for a fair hearing where they have confidence in those adjudicating the matter. And the PDP does not have confidence in this particular panel as headed by the CJN. I think it becomes very apt that they recuse themselves in order not to taint the outcome of the review with any form of bias. I'm sure after this review, I do not know what else any other person that is dissatisfied with what the outcome will be will want to ask for. Because I'm sure after this review, it's before the court of God Almighty himself, that anybody can get any form of reprieve. if they're satisfied with the outcome of the review. So in order not to taint the outcome of the review with any form of bias, I think it is actually in the best interest of the judiciary and the nation for the panel, as presently constituted, to disband for a new panel. And I think the CJN should hear this call.
Thank you for that. But regardless of which way this goes, at the end of the day, what sort of an image does this paint about the justice system as a whole? And to add to that, you also mentioned that there are several areas of concern about this judgment that need to be looked at. What areas of concern are you talking about?
In fact, the most glaring areas of concern here is the fact that, look, at the end of the day, the judgment gave victory to a candidate, pronounced a candidate as victorious in this matter, when, in fact, the total votes gathered by all interested parties appears to have exceeded the number of votes accredited for that particular election. This taints that judgment, and it reveals a manifest error, an inherent error in that judgment. And if it is allowed to stand, it will lay a very bad precedence in our electoral dispute jurisprudence going forward. In fact, I can assure you that a close look at our electoral act, for example, that gives legal backing to our electoral exercise in this country, overvoting itself is an electoral offense. And in some of the polling units, out of the 288 polling units that actually tilted victory in favor of the APC candidate, Chifu Opuzodima, there are glaring facts of overvoting, even inherent in those results that were tendered before the court, that the court admitted, which tilted the balance of victory in favor of the APC candidate. For example, in one of the polling units, out of about 6 that recorded overvoting, a polling in Eziama, Opala area of the state, it was recorded that 492 registered voters for that polling unit. However, the results that was taken to the court revealed a vote garnered for the APC that stood at 809, and the PDP recorded 7 votes. And if you do the arithmetic, this is a 334 excess vote in just one polling unit. And so this goes to show that the excess vote, the overvoting that was recorded in the overall tabulation of the results, which stood at 127,000 plus votes, indicates a manifest error in this judgment. You cannot pronounce a winner in an election where there is a glaring case of overvoting. This is a simple fact, and it's settled in our jurisprudence. And so, because of this singular fact, it's important to review this judgment. It must have been an oversight on the part of honorable justices of the Supreme Court. I do not think this arithmetic was actually a reality that dawned on them when they were making this pronouncement. And since it has been pointed out, there's nothing wrong with the Supreme Court reversing itself. I do not know how they're going to go on. I do not know what they are going to do further. But one thing is certain. There is a glaring case of overvoting in numbers exceeding 127,000. This is very significant. And so, if this judgment is allowed to stand as it is, it's a very bad precedence in our electoral jurisprudence. And so it must be corrected. Because, look, rule of law without morality is void. It's hollow. It's shallow. It serves the interest of only a few and not the common good. As a matter of fact, the laws are crafted to safeguard morality. And there's no morality in overvoting. If this judgment is allowed to stand, it means justice in electoral dispute becomes the exclusive preserve of a privileged few. It is no longer a fundamental human right for all Nigerians who seek legal redress whenever they feel that their mandate have been robbed of them. So I think it's important that the Supreme Court takes a holistic look at this issue. Well, and besides, it has been said to if you look at the antecedents of a former Supreme Court justice who said, look, the Supreme Court is not infallible, meaning that a Supreme Court can always go back to review its judgment. And we do not have to wait for another Supreme Court to review this.
Well, Justice Okuta, you are quoting Justice Okuta.
Jurisprudence.
The Supreme Court is not infallible.
Actually said, that was the import of what Exactly. That was the import of what he was trying to communicate. And the Supreme Court should break with tradition and review this particular judgment in the light of this glaring manifest error of overvoting in its own tabulations.
Well, Majeed Dahiru, we'll take a short commercial break and then we'll return shortly and the conversation would continue. Just stay with us. We'll be right back. Welcome back to the morning show here on the Arise News channel. Still with us in our Abuja studio is Majeed Dahiru, a journalist, syndicated newspaper columnist, and political affairs commentator. Majeed Dahiru, let's go back to this point about Imo State. But first, I think the point needs to be made that, there are lordships in the Supreme Court who only deal with the material facts before them. And they are not expected to act as Father Christmas to make up for the negligence on the part of litigants, if that can be established. However, what do you think are the lessons, without prejudice to the outcome of the review that is now going on? What lessons do you think that all of us can learn from what has happened so far in the Imo State case, and also perhaps in Bayelsa, from INEC to the political parties to the voting population, because it will appear that Nigeria's return to civilian rule or to democracy is trapped somewhere in that learning curve syndrome for more than 20 years.
Yes. Yeah, it's unfortunate that 20 years after the return to civil democratic rule in Nigeria, we appear to still be stumbling and fumbling all the way. And 20 years is enough a time in the life of any nation to have actually attained maturity in anything it wants to do, including, of course, is electoral democracy. Some of the vital lessons to learn from this issue is this. I have always argued against the over-reliance on technicalities when it comes to electoral adjudication, because we are talking about democracy, the people's will. Sometimes the people's will, people power, becomes compromised on the exigencies of technicalities of the letters of the law. I would suggest to our respected jurists across the board that, look, we need to begin to look at substance and as well as the morality behind the rule of law. And by this way, I mean the intention, the intention behind the letters, the spirit behind the letters, and which is supposed to be, in this case, to safeguard the people's mandate. Nothing should ever be done to violate the people's mandate on the guise of technicalities. We may need certain judicial reviews to take care of this kind of judicial, I don't know the right word to use now. We may need some level of review of our current legal framework that governs our electoral system. The case of Bayelsa, for example, is also one case that is very worrisome. People voted for a particular candidate. And what is in doubt, what is not in doubt is whether or not the candidate garnered the majority votes. But what is in doubt today is because a running mate who was alleged to have forged certificates has now nullified the people's mandate popularly given to a particular candidate. This is very worrisome. And I think we must begin to find a way to safeguard people's mandates without compromise on our laws. And this is by reducing our reliance on technicalities. In fact, I would suggest trial by jury in electoral dispute going forward. We have members of the community should be able to come as witness, as independent witnesses, to actually give testimony on what happened in their communities. You know, the law should be organic. It should be made to have life. Our inorganic judicial system makes such judicial accidents inevitable. That has happened in Imo as well as in Bayelsa recently. And it's something that we have to correct. Otherwise, we'll keep compromising people power and undermining the people's will, the people's mandate on the altar of technicalities. So I would think that there is a need for a complete review, administrative review, as well as review of our legal framework, so that we will have less reliance on technicalities in adjudicating electoral matters. Look, without elections, you don't have a democracy. And without democracy, you don't have a nation. Therefore, our elections must be taken very seriously by all stakeholders. And secondly, the players in the field, political parties, actors, we should all try to abide by the rules of engagement. Look, no matter how we amend our laws, no matter the reforms, if it does not come from within us to make that solemn pledge, that commitment, that vow, to pay fidelity to the rule of law, we will always have such problems going forward. So I think it is time for all of us, all interested stakeholders, to understand that, look, it is in our own self-enlightened interest, best interest, to allow processes to proceed in line with the rule of law without taking advantage of any of our laws, because people will not always be there to monitor us. So we are supposed to be law enforcers in our own rights, wherever we find ourselves in our own domains. Therefore, we must do this for ourselves. Nobody will do it for us. Otherwise, we will keep lamenting 20 years after transition from military to civil democratic rule. We will keep lamenting on the same point of getting right our electoral management system. So I think it is the right time. The time is just right for all of us to come together, the judiciary, the political players, the electoral managers, INEC, and all of the relevant stakeholders, to rededicate ourselves, commit ourselves to the spirit and the morality of the rule of law as it applies to election management processes.
Indeed. I've reviewed the written address by counsel to Emeka Ihedioha, and they raised some of the points that you raised with regards to that onerous factor of overvoting, that component of that Supreme Court judgment. They also say that the Supreme Court did not attend to the geographical spread as is required by Section 179, subsection 2 of the Constitution. However, counsel to Hope Uzodimma also cites the Constitution, and they will say Section 285, subsection 7 makes this action, this review, statute barred, and we all know that that is fatal to any application to a court, that the Constitution has imposed 60 days. It's a brief window of 60 days to dispense with all electoral matters. So both sides are citing the Constitution. To your point about us attending to the spirit and not just the letter, which one of these constitutional provisions is more persuasive in this matter? Because there's also a reason, like you were saying, the people's mandate must be upheld. That is why the Constitution allows for geographical spread, so that someone does not emerge as a victor because they're popular in one particular area. It must be the voice of the whole state. There's also a reason why the Constitution allows just 60 days, so that election matters do not drag on endlessly. So where do you think the balance should... Okay.
Thank you very much. In fact, given the manifest error in this judgment arising from a sanctioning of overvoting at the highest court in the land, I would think that the Supreme Court should be more eager than any other party to review its own judgment, because if it does not do this, it will set a precedent. All other people will simply bring up figures and go to court, and overvoting will no longer matter in our electoral jurisprudence. It will take a very long time. And do not forget, cases of electoral disputes involving House of Assembly, State Assembly, and National Assembly matters do not go beyond the appeal court. Meaning that the appeal court cannot overturn a precedence that has been laid out by the Supreme Court that has sanctioned overvoting at the highest court. So for me, it's not even about Uzodimma or Ihedioha. In fact, INEC should have been one of those that should have applied for a review of this judgment. And like I said, the Supreme Court should be eager, more eager than any other interested stakeholder in this matter, to review this judgment. I believe that victory can go either way. It depends on how both counsels are able to argue their cases. That is immaterial. Victory can go to Uzodimma, it can go to Ihedioha or any other interested party. It is immaterial to us as Nigerians. What is of concern to us is the highest court in the land appears to have sanctioned overvoting in a legal pronouncement, a landmark judgment. And if it is not reviewed, it becomes a bad precedent going forward. And in this instance, back to your question, it is more expedient to break with tradition and review this judgment and do not, again, rely on the technicality of being statute barred not to do this, because that will actually, set a very bad precedent that all of us will live with for a long time. And so I do not think that in this instance, the technicality of being statute barred applies. This is a manifest error. It is like sentencing somebody to death at the highest court for a crime that carries a maximum of 2 years imprisonment, for example. So it is this grievous. So it's something that the Supreme Court has to review. There is a clear case of overvoting, and this is the most important thing here. I do not really care much about what other, the counsels of both parties. I'm not a lawyer. I do not have legal authority to speak on core legal issues. But what is of concern to the ordinary Nigerian is simple. A clear case of overvoting, which in itself is an electoral offense, has been sanctioned by the Supreme Court. Something has to be done about it. Otherwise, it becomes a precedent that will bind on all of us for a long time to come.
Certainly. And to widen this discussion as well, I also want to look at the role that politicians have to play in all of this as well, because what's sad is that it shouldn't even have to get to this in the first place. Yet here we are discussing several election tribunals over time with different outcomes that are all controversial. And it raises a serious question about the role that politicians also have to play from the get-go and the importance of electoral reform. How much of a role do you think that politicians and political parties have to also play right from the very start of their electoral campaign, or whatever the case may be, when it comes to situations like this?
You see, Nigeria is a country that has defied all known solutions to any problem that has bedeviled it. Solutions that work for other people do not work for us. And that is because we as a people are impervious to these solutions. The major problem, the crisis you are seeing today, was created by the political class. And this is because Nigeria's political exercise, our politics in Nigeria, in 20 years has degenerated to a criminal franchise of power grab for self-service. And so politicians devise every ingenious means, even ingenious means, to grab power at all costs for self-service. Otherwise, if the intention is to serve the public, I do not think politicians will go through all of this stress, undertake all of these acrobatics just to remain in power or to seize power from opponents. This is where the problem really lies. And no matter of reforms, no matter how beautiful our laws are crafted, if our politicians refuse to imbibe morality and fidelity to the spirit and intent of our extant laws, they would always find ways to undermine our processes. And so I think the conversation going forward should be on the conduct of politicians. Our politics is devoid of morality, it's devoid of conscience. It is simply a self-serving, self-seeking agenda that pervades the entire polity today. And until this is reversed, no amount, no matter how beautiful your laws are, it will always be undermined by this set of politicians. So the problem really is the political regime of Nigeria that have decided to compromise all institutions of state, all processes, on the platter of the experience of their political ambition, their self-political ambition. And until this is corrected, until we focus and beam the searchlight on the political actors, we will continue to witness such judicial acrobatics from now till eternity. And it's important for us to begin to have this conversation about the conduct of politicians. They have derailed our democracy in 20 years due to their irresponsibility, their immoral conduct. They have retarded the growth of our democracy for in 20 years. In 20 years, we are still on the learning curve. We are supposed to have surpassed this learning curve even within the first 8 years of our democracy. But that is not the case. Electoral banditry is now a free-for-all in this country. And what has been the result? Administrative banditry, because you cannot put something or nothing and expect it to stand. When you have a process throwing up political leadership that would superintend over the affairs of Nigerians through the most barbaric means, it's simply a recipe for an equally barbaric form of governance, as we are seeing today.
Well, thank you very much.
We begin to hold accountable our political leadership.
Thank you very much, Majeed Dahiru, on that note about checking electoral banditry. we have to bring this to a close. Thank you very much indeed for coming to the morning show.